afternoon, everybody. I'm so happy that all of you are joining us in a webinar. We're just in, and I have a little housekeeping. Since this is in a webinar format, we will all be in listen-only mode. So what that means is that on the right side of your computer, if you're utilizing a computer today, you will be able to type in your questions. Again, there is a space on the right side of your computer where you could type in your questions. And so at the end of the presentation, we will be reading the questions for our presenter. So once again, for the convenience of everybody and for better listening, we will all be in listen-only mode. I just would like everyone on the line to know that. And so now we're going to begin our Care Connection program. Today we're so very excited to have Robert Friedman. He's a partner at Schiff and Hardin. He's an elder care lawyer who began his career in elder law 35 years ago. He's a nationally recognized expert and true pioneer of the field. Today, Mr. Friedman will be discussing fundamentals of legal planning. So, Robert, why don't you tell us a little bit about yourself, and we will now be starting the presentation.
Okay, as you mentioned, I've been an attorney practicing in this field for 35 years. I was at Brookdale Center on Aging and Legal Services in private practice. I've been on the board of the Alzheimer's Association in Hudson Valley, New York, and have been working with clients who have Alzheimer's and their families for over 35 years. And what I want to cover today are the fundamental legal and financial matters that every family that's addressing this issue has to deal with. And I'm going to start with the first slide, which is HIPAA medical privacy release forms. Should be coming up. This is crucial for everybody. It's a form, HIPAA medical privacy release form, which is available online, is available from doctors, it's available from lawyers. And what it is it authorizes the medical advisors to release medical records and discuss medical conditions with the people you designate. So if you're caring for a spouse, it's important that the spouse authorize the doctors to talk to you. They'll often talk to spouses, but if you're a child caring for a parent, they may not talk to you unless you have authority. It has to be in writing. Otherwise, you'll start hearing doctors say, I can't talk to you, you're not the patient. So this is a form that we have every one of our clients do. And not only the person who may have dementia issues and memory loss, but also the caretakers. Everybody needs to do these forms. Sometimes you'll see them witnessed or notarized. It's not necessary, but it has to be in writing. Crucial form number one. If you go to the next slide, this is a healthcare proxy. With any dementia, there comes a time when the person will not be able to make their own medical decisions. And then the question is, who makes those decisions? So while a person still has the capacity to decide this issue, it's crucial and urgent that they appoint the person they want to make the decisions. Usually it's a spouse or a child, but if there's somebody else they trust, a brother or sister, they can appoint that person. The form in New York is a healthcare proxy. Some states call it medical powers of attorney. If you do this form, it will be recognized in every state. It'll be recognized wherever you need it. In fact, in general, it's recognized in foreign countries. You have to appoint, somebody's got to be appointed to have the legal authority to make a medical decision. Now, New York State requires you appoint one person at a time. So if you're considering naming children, you can name all 3 children, but you need to name them one at a time. If you're thinking of your wife and a child, you can name them both, but one at a time. When you appoint this person, they can make any and all medical decisions. Surgery on a broken wrist, whatever needs to be done. Decisions about artificial hydration and nutrition, unusual, but if it comes up, the agent must know the actual wishes. So the form usually has on it, my agent knows my wishes about artificial hydration and nutrition. Again, crucial form. Next slide. Living will. Living will is a statement of your wishes regarding health care, but it's focused on end-of-life decisions. The way it works is it really is a guide or instructions for the agent under the healthcare proxy. So you say, my daughter Joan will make medical decisions if I can't. Then the daughter Joan needs to know what you want done, how you want to be treated. Do you want extraordinary measures? What do you want to be done if there's no reasonable hope of recovery? So the living will provides instructions to the agent under the healthcare proxy. And if there is no agent, it will provide direct instructions to the doctor. That's the third and the last of the medical forms. And I start with those because to me the medical care is the most important thing. And everyone needs them. And the forms that I've talked about so far, you don't necessarily need a lawyer for. These are available online. Next one. Power of attorney. The thing with dementia is over time, people lose their capacity to handle legal and financial matters. If the person's at an early stage, they have fairly strong capacity. At a late stage, they may have no capacity. And the question is, who then steps in? We get phone calls saying, Dad's got $40,000 in a bank account. I got to pay the home attendant. I have to pay this. How do I get at it? And the answer is legally, nobody has the authority to get at that account unless you take some action. And the major way that people deal with this is through a power of attorney. So, for example, I do a power of attorney which says, I designate my wife to handle legal and financial matters. And if she's not available and she can't do it, then my son. It's urgent that everyone have it. I've been doing this planning for 35 years. This is the most important document and we need to do planning for somebody who has dementia. And it's the foundation of all the planning we're going to talk about. The forms and the laws vary from state to state, so it should be done in the state where the person lives, where the person with dementia lives, not necessarily where the caretaker who could be from outside. The form has to be notarized. Some states it has to be witnesses, but in all states it has to be notarized. The form generally has a specific provision which allows the agent, let's say the daughter, to not only pay bills, but to do planning for tax planning if necessary, for estate planning, or for Medicaid planning, which we'll talk about in a bit. And therefore, it's important that the form be done and be filled out and provides these additional powers. In New York State, it's not just an additional power. It's an entirely separate form called a statutory gifts rider, and that form has to be filled out. This form, you can appoint multiple agents. You can say, I appoint my daughter and my son, and you can say that both of them have to sign, or either one of them can sign. Usually it's better to just name one. You can say my wife and my daughter, and either of them can sign for me. The details are defined by state law. The form is defined by state law, and it's the foundation of the financial and legal planning. Unlike the forms I mentioned above, you really need to see an attorney to do this form. If somebody's going to do planning, they have to meet certain requirements, and they vary from state to state, and you need to see an elder law attorney to do this form. Doing it on your own, 9 times out of 10, it doesn't get done correctly. If somebody comes in, I have to figure out if we can redo it. And this is a form which should be done early at any diagnosis of any type of illness, memory disorder. In fact, even just at a certain age, you should try to set this up so that you're not saying give away money now, but I am saying authorize somebody to help you in case you lose the capacity to do it all by yourself. So crucial form that everybody needs. It's a very powerful form. When you appoint somebody, they have the rights to handle your finances. So you can only give it to somebody you trust, your spouse, your children, your brother, your sister. In some cases, people give it to accountants and attorneys, but generally I recommend that you go to family members or close friends, and not somebody in a professional responsibility. So this is the essential cornerstone of all planning. Okay, can we move to the next one? Next form is the Revocable Living Trust. We're talking about management of finances. Could be your house, could be your bank account, could be your IRA, could be stocks, bonds. Usually, in many cases, the power of attorney allows the person to manage it, and it's fairly simple and it works. But in cases where there are more assets, you own a home, you own a co-op, you have a brokerage account, it may be better to go not only in addition to the power of attorney to a revocable living trust, appointing somebody to manage assets. And the way it's usually done by the lawyer is, I set up a trust to manage assets. I keep 100% of control now while I'm competent and can do it. But I have a provision that if I become incapacitated in the future, my daughter can take over and she can manage the assets. She can pay my bills. She can, and file my tax return. She can do all of that. And the way I provide for that is I do a power of attorney to her, and I set up a trust and give her control as the successor trustee. With the power of attorney and the revocable living trust, you're not giving up any rights now. You're setting something up so that in the future, somebody can step in and help take care of you. So this is all stuff which is being designed in case of future incapacity, which means it should be done at the earliest onset of any of the symptoms. The trust has another advantage in that it avoids probate of a will, so it provides for the money and the assets during lifetime, which is most important. It also provides for the distribution after the person dies. Like the power of attorney, this document has to be drafted, state law varies, has to be very customized, and you should be seeing a lawyer for it. Next slide. Those I've talked about so far are essential for everybody because this is something that everybody's got to deal with. What happens if I can't handle things myself? I started with the health, I went to the finances. Now we're going to talk a little bit about insurance, paying for care, the cost of care, and how that gets dealt with. And with illnesses of dementia or Alzheimer's, it's different than somebody who's concerned about cancer or a heart attack. It's totally treated differently under our healthcare system. So let's go through how you start with this. Almost everybody over age 65 gets Medicare. Even if they don't get Social Security benefits right away, they get Medicare. And somebody who has Alzheimer's in early age and early onset before age 65 becomes eligible after they've been disabled and getting Social Security disability benefits for 24 months. But for most people, they get it at 65. Medicare is an insurance program. You've been paying Social Security taxes for these years. Everybody's been paying taxes to help support this, and this is what you get in terms of insurance. Medicare has Part A. That covers hospitalization. It also covers some limited rehabilitation. Not a lot, but some. That is included. So when you turn 65, you get that automatically. There is no deduction from your Social Security check. It comes free. The second part of Medicare is Part B. That's what pays the doctors, the labs, and other services. That has a cost, and that gets deducted from your Social Security check. Almost everyone has Part B. There'd be very few reasons why you wouldn't, and that comes from your check. Medicare, while it provides insurance, has deductibles and co-payments. There's some deductibles and co-payments under Part A for hospital, and there are deductibles and co-payments under Part B. Doctor's care is only 80% of a Medicare rate. It's not 100%. Hospital coverage is limited in days, and there's some co-payments. So therefore, if you've got Medicare, you have decent coverage, but it does have gaps. And there are two ways you can address the gap. One is you can sign up for fee-for-service Medicare, regular Medicare, in which case you've got deductibles and co-payments, and people deal with that by signing up for a Medicare supplemental insurance, sometimes called Medigap insurance policy. That, if you're going to go with that route. Some people prefer, instead of having to pay the extra policy, they prefer to sign up for Medicare Advantage. Medicare Advantage is managed care. You don't necessarily have to pay for a supplemental policy, though sometimes there's a little bit of additional coverage, premium coverage. You get broad coverage. You don't have all the deductibles and co-payments. It's managed care, which means you may not be able to see every provider. And in some cases, you may have to see a primary physician before you can see specialists. It's a lot less expensive. It saves a lot of money. This is a time of year where you can go, if you have Medicare fee-for-service, you can switch to Medicare Advantage. If you have Medicare Advantage, you can switch to fee-for-service. If you have Medicare Advantage, you can switch to another company. All of you have probably been getting numerous mailings, telephone calls saying, come to Oxford, come to Aetna, come to our Medicare Advantage program. You'll get coverage. There is no right answer as to what the person should do. Medicare Advantage will be less expensive. It limits who you can see. In general, Medicare Advantage often works very well for younger, healthier people because it costs less money if they've got doctors who they're comfortable with who are on their program. The problem is if you then need more care, and a lot of people with Alzheimer's will need that either because of the dementia issues or because they have other health issues, since many are going to be elderly, over 80, let's say. And in those cases, Medicare Advantage may have the problem it may be too limiting. There is a lot of help. I think the next slide has some of this information. This is when you can switch. There's a website, Medicare.gov, that has a lot of material on this. There are Medicare advocacy websites which are available. If you Google Medicare advocacy or Medicare benefits, you'll find websites that are designed for consumers rather than just a government one that guide you as to whether or not it will compare Medicare and Medicare Advantage. Depending where you are, if you type in a zip code, it will tell you what plans are available in your area and what they cover. You've got to search, and you only have the next month or so to switch. If you don't switch now, you're stuck with it for the next year. So I know it's difficult. It's particularly difficult if you're taking care of somebody, but you really do need to look to make sure you're signing up for the best plan. And this part of the discussion is for everybody. So everything I just said is not just for the person who has been diagnosed with some type of dementia, but it's for the caregiver as well, assuming the caregiver is over 65. Everybody has to deal with this. The problem in particular with Alzheimer's and other dementias is that Medicare provides almost no coverage, no long-term coverage. You don't get, your nursing home care is only for rehabilitation, short-term, very limited. Home care for Medicare, only rehabilitation, short-term, very limited. People with Alzheimer's and dementias need long-term care, chronic care. Medicare provides almost no long-term care coverage. I had a partner who used to say it's sort of a risk. It's kind of a wheel of fate. If you happen to have cancer or heart problems, you've got great Medicare coverage. If you happen to have Alzheimer's, you have terrible. My mother had heart operations. She was in the hospital for the operations for a week, recovering in the hospital for a month and a half. She had Medicare and some supplemental policy. She ended up being liable for the cost of the television. Everything else was included. Everything else was covered by Medicare and the Medicare supplemental. She had cancer and she had needed treatment. Everything was covered. My father had dementia and he needed an aid and he needed assistance. None of it was covered. When he had to go see the cardiologist, that was covered. But when he had to have the aides there 12 hours a day and all that, that was not covered. There's a huge gap. So while everybody's got to deal with the Medicare, unfortunately, you have to recognize with people with dementia, Alzheimer's, or any other type, chronic conditions, and this applies to Parkinson's and ALS and some other chronic conditions, your Medicare is not an answer. It provides almost no coverage. Can we flip to the next one? Long-term care insurance. Long-term care insurance pays for home care, pays for nursing home care, pays for the things that Medicare and Medicare Advantage and Medicare Supplement does not. If the person who has dementia has long-term care insurance, there's probably a lot of coverage. There's going to be something that will be covered. You've got to look at the policy. You may want to hire a professional to go over and figure out what's covered, and you can get some coverage. If you don't have the policy, you can't get the policy if there's been any diagnosis or doctor's visits due to any memory issues at all. So you had to have had it before this diagnosis. For the people who have it and you're the caretaker for them, it's too late to do something. But spouses and children should at least maybe consider whether or not they should be buying long-term care insurance. We've had people who have great coverage. Probably if a client comes into my office after they've had some diagnosis at all, it's too late for me to get them coverage at that point. So you flip to the next one. I'm covering distribution upon death, not because, to me, it's not the focus of care. Focus of care is during lifetime, taking care of the patient, taking care of the family, spouse, some cases children. That's where the focus has to be. But people ask these questions, so I just want to just touch on them because we're covering some of the legal issues. People need to realize if they're concerned about what happens to their estate, many assets, retirement accounts, IRAs, 401ks, 403bs, life insurance, annuities, all designate beneficiaries, and that's what controls. And one thing to keep in mind is if you're dealing with a spouse who has this disease and you designate them as the beneficiary of your retirement account or your annuity, something happens to you, there could be a real problem because if they inherit it and they can't manage it, you can end up in court guardianship proceedings and things like that. So it's at least worth looking at. The person who has the Alzheimer's, you've got to look at their accounts. Joint assets. Joint assets are accounts which have a couple names on them and are almost always set up so that either person can take the money out. And people will say, no problem, I'm joint with my mother on the accounts, I can pay all of her bills. And in some cases that works. Or I'm joint with my husband, and in some cases that works. But sometimes it doesn't do what you think it does. For example, we've had a lot of clients come in, mom passes away, they come in and they say, well, everything was joint with Joan. Joan lived in New York with mom. The will says everything goes equally to the 3 kids, but all the accounts were joint with Joan. And the other 2 kids who live in Chicago and in Los Angeles say, she just did that for convenience because Joan was there and handling the bills, but she figured once she died, everything would be divided up. And Joan says, well, no, I was the one taking care of mom. I get everything. And I look at the account and say, it's joint account. Generally, everything goes to Joan. That's not what mom wanted. That's not the way she should have done it. So joint assets can be really problematic. Does it work for that small checking account with the person who really is going to pay the bills? Yes. Does it work for that $300,000 brokerage account? Probably not. Unless it's between husband and wife, which maybe it will work for, or unless it's between a parent and an only child. I'm an only child. My father, after my mother passed away, could hold everything jointly with me. I was the only one who was going to get it. My wife's one of 2. Her mother can't hold everything jointly with her. That would disinherit her sister, which is not what's wanting. So it's very specific to the family. You have to be very careful. When you see a lawyer, they will not only go through the legal documents, they need to look at the joint accounts. And the next topic we're going to come to in a minute is going to be Medicaid. I want to talk a little more on this. Medicaid says it's a joint account between mom and daughter. Mom's applying for Medicaid. Medicaid says that's mom's account. We don't care that it's joint with the daughter. It's mom's account. There's some exceptions, but generally it doesn't work as Medicaid. Can you back up one slide for a second? Okay, so joint accounts don't work. Having accounts which designate beneficiaries, which are life insurance or transfer on death TOD or pay on death POD, or bank accounts in New York are in trust for, those distribute upon death, that's okay. And we talked about the trust before, that distributes upon death, that's okay. You got to be careful with joint accounts. So people talk about their will, their will, their will. The will only provides for assets owned alone without designated beneficiaries. It's important, but in most cases, that's not most of the assets. Now let's flip over to the next slide. All right, this is I've been doing elder law for all these years. Medicaid planning is sort of the heart and soul what most elder law attorneys do. And the reason for that is that care for somebody with Alzheimer's is expensive. In New York City, where my office is, nursing homes are $500 to $700 per day. You can do the math. We're looking at $20,000 per month, a couple $100,000 a year. People who have had lifetime savings, they can be eaten up very quickly. You spend a year or 2 in a nursing home, it costs more than your home costs. It is the largest potential healthcare expense. For almost everybody, they could have some Medicare costs and they could have some doctor's bills, and we're talking hundreds or a few thousand here or there. If you're talking nursing homes, you're talking hundreds of thousands. And Medicare does not cover it. So if you do not have long-term care insurance, or if the long-term care insurance isn't adequate, then you have to pay for this care privately or qualify for Medicaid. Medicaid is what pays for almost all nursing home costs in New York State, as well as huge amounts of home care. We are talking about a budget of $100 billion. County by county, the cost for paying for Medicaid for people in nursing homes and home care is often greater than the cost of schools. The numbers may be less, but the nursing home is getting $100,000 a year. The school is probably getting $20,000 for each student. It's the largest part of the New York State budget. New York State, unlike other states, actually makes the counties or New York City contribute, and for many of them, it's the largest part of their budget. This is an enormously expensive disease, and you've got to take some steps to figure out how you're going to pay for it. People say, well, Mom's got enough money, I'm not worried about it. She's got $400,000. Fine, that'll last a couple years. Then what? People can have Alzheimer's, can be in nursing homes for a couple years, they could be there for 15 years. Everybody who is dealing with this disease is facing this risk and this cost. So you've got to do Medicaid planning. And in terms of what, as an elder law attorney can save, the earlier you do the planning, the more that can be protected. I can't emphasize that enough. Any early symptoms means you have to jump in and plan. There are people who come, to me and I say, okay, we're going to set this up. Hopefully, it'll be many years before we need to worry about home care or anything like that. But we might down the road. That's a lot easier. I can protect a lot more than my father's in a hospital or in a rehab. He needs to go to a nursing home or he needs to go home with 24-hour care. There are some things I can do, but not nearly as much. So you have to do the planning early. You need to consult an attorney who's familiar with Medicaid. That and maybe a little with power of attorney is what distinguishes an elder law attorney from sort of a general practice attorney or a trust and estates attorney. They know about the planning that way. And you need to see somebody who's familiar with the area where the care is going to be provided. Laws vary from state to state, and the implementation of Medicaid and services varies from within a state. The way we get what Medicaid pays for in New York City and what's available under Medicaid is very different from what's available in Rochester. And what's available in New York City and Rochester is very different from what's available in New Jersey or Connecticut. You need to see an attorney, and you need to see an attorney familiar with where the person is going to be cared for. There are ways to qualify for Medicaid and protect assets. I wouldn't be sitting here telling you need to see an attorney if there was nothing the attorney can do. There are things that can be done. Not necessarily to protect all the assets, but there are things to protect some. There's money. So flip to the next page. And then we've got Medicaid tips. There are major protections for spouses. So if the husband has Alzheimer's and may need care, there are protections for the wife. And that's true whether the husband needs home care or nursing home care. They vary from state to state. New York State is more generous than other states, but there are protections in all states for spouses. Congress and the state governments have recognized that there has to be some protection against spousal impoverishment. I wish it was more. I wish that the coverage for Alzheimer's was the same as the coverage for cancer or heart. It isn't, but there are protections. But to use them, you have to do it correctly. You have to file correctly. You have to set the finances correctly. You really do need to consult an attorney. There's specific protections for a home. That could be your house, your co-op. It could even be the three-family house in Windsor Terrace that you own and somebody rent out. There are protections for the home. Some of the times that they're totally protected. Some of the times they're protected during lifetime. Sometimes they're protected for the person who's at home in the spouse. Sometimes there are additional protections for the children who live there, helping to take care of the spouse, the person. There are protections for the home. For most people, that's their most valuable asset. And there are things that can be done, and they have to take steps to do them. There are special rules for tax-deferred accounts, IRAs, 401ks, 403Bs, tax-deferred annuities. It's a partial list. There are special rules allowing those funds to be protected. Most of those funds are protected against other creditors, the credit card company and things like that. For the most part, they're at least partially protected if the person needs Medicaid. So a client who has $100,000 in an IRA does not have to spend the full $100,000 paying for the nursing home. The lawyer can protect most, if not all of it, but certainly most of it. How much varies a bit from state to state and even varies sometimes within the state, but definitely substantial amounts can be protected. Sometimes as much as all, otherwise, very substantial amounts. There are very special protections for disabled individuals under 65. So if it's an early onset and the person's under 65, there's special rules for them. And there's special rules to protect children who are disabled. So if mom's got Alzheimer's and she's got a child who's disabled, there are special protections to get mom on Medicaid and get the money protected for the child. Special rules for disabled individuals, whether it's the person applying for benefits, the spouse, or children. And then to some degree, even grandchildren and other relatives, which is again why you have to see an elder law attorney. There are ways to giving some of the money away and qualifying for Medicaid, but there are severe penalties if it's not done correctly. And sometimes it makes sense to do this and sometimes it doesn't, but that's why you go to see somebody to advise you on it. Which leads us to the next slide. Do I need to consult an elder law attorney? I talked about the first things that everybody should have, the living will, the healthcare proxy, and the HIPAA, and those things are all available online. You don't need a lawyer. But when you're doing a power of attorney, particularly for somebody who has Alzheimer's and there's a risk you're going to need medicated things, it has to be customized. It's got to be done by an attorney who understands it. If you're going to be looking to Medicaid, because Medicare won't pay for the care, it has to be a lawyer who understands Medicaid in that area. If you're going to do a trust to manage the assets, it has to be a lawyer who understands how the trusts work. So while I don't like being out there saying you got to go see a lawyer, in these cases you definitely do. Now, if a person has no money at all, it's less of a problem. But if there's a spouse involved you're trying to protect, if there's a house you're trying to protect, if there's a retirement account, you really should see a lawyer. So if you need to see a lawyer, how do you find them? Well, there are a number of organizations, bar associations, organizations that deal with diseases like Alzheimer's, that keep referral lists of attorneys specializing. The New York State Bar Association has an elder law special needs section. There's a National Academy of Elder Law Attorneys. That's national, so they're not quite as helpful locally. There are social workers and people in, all of these people know lawyers. Word of mouth is generally a way of going. I have no idea if there are things on Angie's list or anything like that, but you want somebody who knows their stuff and can be honest and trustworthy. And you should ask, what are your fees going to be and who am I going to be meeting with? Be a good consumer. If they say come in for a consultation, you're entitled to say how much will it be. Or if they say that's free, you can say yes, but what happens next? Ask questions. Lawyers should be able to tell you how much it's going to cost. They may have to say, this is how much it will cost in the beginning. We're going to have to see what happens, but they should be able to give you some idea. They should talk to you. It may not be the lawyer you're going to see. It may be somebody else. Back up for 1 second. Free legal services. There are, and I'm again in New York, there are some, generally, there's volunteers to legal services and other ones, and there are some that will also specifically help out with Medicaid home care. Usually you have to qualify. Usually you can't have income limits, and then there are asset limits. Some of them are around $40,000, but there are some places available. There are some places that have reduced rates. But if you're talking, I've got $100,000, I'm worried about Medicaid, they're not going to want, you're not a priority for them. They say you can afford to pay for an attorney. Okay. Next page. And we've got the stuff for the Alzheimer's Foundation, and I don't know if you want to chime in and just point out that there are a lot of services that are available there.
So thank
Heather,
you. I am on. So Robert, first I want to thank you for such a great comprehensive webinar today. Your presentation, I certainly learned something new, and I hope everyone else on the line learned something new today. But before we begin the question and answers, I just want to quickly review some of the resources that we offer. Here at the Foundation, we have our helpline. So if anyone has questions connecting with certain services or have questions regarding this disease, our helpline is available Monday through Friday, 9 a.m. to 9 p.m. Eastern Time, and on Saturdays from 9 a.m. to 1 p.m. Eastern Time. We have our Training and Education Division, Dementia Care Professionals of America. We have our National Memory Screening Program that is in November and year-round. We have our webinar, which everyone is listening to today, and we certainly have our free quarterly magazine. And so I want to let everyone know next month we will be having Eric Hausman, and his topic is going to be an overview of Medicare, and that's going to be on December 8th, 2016. So if anyone has any questions, I just want to remind everyone you could certainly type them in on the right side, and we'll read the questions, and Robert will answer.
While you're checking to see if there are any questions, one thing I didn't discuss is for veterans and veteran spouses, there are some services available through the Veterans Administration. And you can find that out online or call the Veterans Administration or call any of the war veterans groups, American Legion, and they'll tell you there's something called aid and assistance that does provide some assistance for like aids and partial payments of assisted living and things like that. New York doesn't have a lot of veteran VA nursing homes or hospitals, but it does have this aid and assistance.
Well, thank you for letting us know that, specifically on the Heal Up Tomorrow being Veterans Day. So these are questions that we get on the helpline a lot. So thank you for pointing that out. I do have a question from Lisa Minert. Just to clarify about the joint accounts, can you explain again which takes precedence, the beneficiary's name in the will or beneficiaries named in the joint accounts?
Good question. The joint account takes precedence. So if the account's joint with Joan, as I said before, but the will says split everything between my 3 children, Joan gets everything. So, like I said, I was an only child, worked very easily, but otherwise it gets very complicated.
Thank you so much for helping with that question. We have another question. I'm sorry, we have another question. No? Oh, I am so sorry. With long-term care insurance policies, is there an organization that you could recommend if someone's researching on what could be the best policy for them?
There are agents who sell policies from multiple companies. So you can ask a lawyer or somebody to give you the name of 1 or 2 agents, and you can even find out, the names of the agents, and if you talk to 2 or 3 agents, they will explain the differences in one policy over the other. And you really just have to compare between them. There isn't like one central screening, and the companies change every year, and the policies change every year. So my suggestion is, same thing I would tell somebody who's looking for life insurance. Talk to at least 2, maybe 3 agents, have them explain how they work, and then you can make a decision.
Okay, thank you so much. We do have another question from Michael Ellenbogen, and he says, I would like to see where in the future we can ask questions. Oh, this is for us personally here at the Alzheimer's Foundation of America. verbally rather than in writing. Unfortunately, with the webinar service that we utilize, the questions could only be typed in. There's not a way for us to get them verbally with this new system. So for everyone on the line moving forward, the questions could only be typed in, not asked via the telephone. We do apologize, but that's the system that we are utilizing. Another question for you, Robert, is that if someone had signed like healthcare proxies, DNR, do not resuscitate, do not intubate, and they live in New York, and then they move with their child to California, advanced directives, are they nationwide recognized, or is it when you go to a different state you have to change your paperwork?
The ones you've talked about, you mentioned there, are recognized nationwide. The only thing you sometimes need to do is a new power of attorney, and that's usually if you buy property, real property, a house or something in another state. But the other advanced directives are recognized, not only nationwide, we've had them recognized we recently had one in Italy and one in France, and the doctors there recognize the authority of the son to make decisions.
All right, thank you so much. I do have 3 more questions from Susan Wingal. I'm sorry I'm pronouncing your name wrong, Susan. If I have a healthcare proxy, can a hospital require that I fill out their form about health representative when admitted? When I'm sick, I'm concerned I'll fill out wrong or feel pressured by a family member who took me to the hospital.
Okay. I mean, the answer is you probably should bring it with you, or have the family member you appoint be available so that if you're there and they say we need one, you don't have one on file, that person can fax it or scan it over. They have to ask about it. They shouldn't. If you have one already, that should be fine for them. So it's important that the agent you appoint be available and can send it to them. I'll tell you one quick story. I was going in for some surgery, and they sat down and said, you have to sit through this video on healthcare proxies and living wills before we can admit you. And they flip on the video, and it's a video that I had done for a national organization with Hugh Downs, who used to run the Today program, on what is a healthcare proxy. So I'm sitting down watching myself talk about it, and they absolutely insisted I sat through it anyway. If you have the form, bring it with you. If you've got the form, make sure it's available. Some people actually reduce it and keep it in their wallet or their pocketbook.
Okay, thank you so much. We do have another question from Barbara Swedson, and she would like for you to explain what a pooled trust is.
Okay, the question about a pooled trust is about Medicaid, and it has to do with people who go on Medicaid for home care. We touched on it, we didn't go into in depth. Medicaid pays for nursing homes, Medicaid pays for home care. If people are getting Medicaid home care, oftentimes their income is higher than the Medicaid rate, and let's call it $850, it's a ballpark number. And so they have extra resources. Medicaid says, well, you got all this, your income's $1,000. We want you to pay us $150. Pooled trusts are not-for-profit organizations that have this arrangement to call the pooled income trust, where instead of paying the $150 to Medicaid or to the home care agency, you pay it to the pooled trust, and they then turn around and use it to pay rent or cable or Con Ed or something else. So you're protecting your income that way. It's for people on Medicaid home care. If you got a Medicaid home care, they should be able to explain how it works. And otherwise, you can look at the pooled trust. All have websites that explain it. But it points out that there is help for Medicaid home care, and you're not going to be impoverished if you do it. There are ways of protecting your income.
Okay, and this probably will be our last question, Robert. I'm so happy we have such inquisitive minds today. I love it. So this question is from Nina Marie Scherer, and her question is, what is the difference between a conservator account and a personal account with the guardian conservator listed?
Okay, New York State doesn't have conservators or conservators. They have guardians. And the guardian has to be appointed by the court. So if the account's in the guardian's name, it means there was a court proceeding appointing a guardian. And if a guardian's appointed, all the accounts are supposed to be put in the guardian's name. In general, you know, very few people get guardians. If somebody's got Social Security and they can't manage it, Social Security has something called a representative payee, where they'll send a check to a spouse or a child to handle in case of dementia. Other pension companies all have the same thing. So if you're really seeing something that says, a conservator was also court appointed, says conservator or guardian, there would have had to have been a court proceeding, so it's got to be pretty complicated.
Okay, well, thank you for that answer. It doesn't seem like we have any more questions. We have a couple more moments, so if anyone has any other questions, we do, now would be a time to type it in. I'll wait a moment's time. Okay, so it doesn't seem like we have any more questions. We've had amazing questions, so I'm really happy for everyone who participated. Robert, I'm specifically happy that you joined us today and volunteered your time and your knowledge. Thank you so much. I hope everyone will join us back next month. Again, that is for December 8th, and our guest presenter will be Eric Hausman, and he'll actually be doing an overview of Medicare. So today, Robert touched upon Medicare, and Eric Hausman's whole presentation will be on different aspects of the Medicare program. So again, I hope you all join us back next month, and I hope everyone has a wonderful rest of the day. Thank you, everyone, for joining us today for the webinar.
Okay.